Good afternoon. I'm Alana Cohn-Kennedy, the Chief Operating Officer of the Holocaust Center for Humanity. I'm speaking to you today from beautiful Seattle, Washington, the traditional land of the Coast Salish peoples. Welcome to the Holocaust Center's 100th Lunch and Learn program. That's right, you heard that correctly. This is number 100. I know there are some of you watching this program that were at our very first virtual Lunch and Learn program on March 30th, 2020, with Ari Cohen, who shared the stories of his 4 grandparents who were all survivors of the Holocaust. If you watched that first program, let us know. By the way, the chat is open, so we welcome your comments. It's a great way for everyone watching to connect, and also one of the perks of watching this program live. The virtual Lunch and Learn series was started as a response to the COVID-19 pandemic, when everything was shut down and we were all in our homes, uncertain of what was to come or for how long this might go on. These programs were a way to continue bringing people together, sharing stories, educating, remembering, and exploring hard topics. You all were amazing. You kept coming, kept watching, asking questions, sending in suggestions for speakers, and wanting more. And here we are in January 2023 on program number 100. In the last 100 programs, we have met so many people from all around the world: Holocaust survivors, survivors of other genocides, descendants of survivors, scholars. We had topics such as rescue in Bolivia, letters from a Dachau liberator, Nazi hunters, propaganda versus news, the real Nazis of the Northwest, people with mental illness and disabilities during the Holocaust, Jim Crow laws and Nazi racial policy, and so many more. Almost all 100 of these programs were recorded and are available for you to watch on our website. These programs aim to present perspectives and voices that challenge and inspire people to confront bigotry, racism, and indifference, and to consider how our actions make a difference. I have truly loved being able to share these remarkable speakers and stories with all of you, and I look forward to more great conversations and questions throughout the year. I want to invite you all to our next Lunch and Learn program, to our next in-person program that is not a Lunch and Learn on January 26th at the Museum of Flight. And this will be in honor of International Holocaust Remembrance Day. The program is in-person only and will discuss one of the lesser known aspects of the Holocaust, what has become known as the Holocaust by bullets. One of the turning points in the history of the Holocaust was the Nuremberg trials. After the war, the top surviving German leaders were tried for Nazi Germany's crimes. Their trial was held before an international military tribunal in Nuremberg, Germany. The Nuremberg trials were an attempt to seek justice and to hold perpetrators accountable. But when crimes against humanity are committed, can justice ever be done? This question continues to confront us today, as so many atrocities go unpunished and perpetrators escape responsibility. Professor Babafemi Akinrinade, in his recent book, Atrocity Crimes, Atrocity Laws and Justice in Africa, examines the laws and efforts to bring the perpetrators to justice. I'm honored to have Babafemi here with us today to discuss the different means for holding perpetrators accountable for crimes committed in conflict countries in Africa. As justice for victims has been elusive, with suspects fleeing to other countries, trials before foreign courts, especially in Euro-American countries, have proved significant. There are lessons to be learned to bring justice to the victims and to the world. Babafemi Akinrinade is Professor of Human Rights at Fairhaven College, Western Washington University in Bellingham. His teaching and research focus on international law and international human rights and mass atrocities. He is the Associate Director of the Ray Wolpow Institute for the Study of the Holocaust, Genocide, and Crimes Against Humanity at Western Washington University. We will have time for Q&A at the end of the program. Please add your questions to the Q&A feature on Zoom at any time. Babafemi, thank you so much for joining us today from Bellingham.
Thank you very much, Ilana, for this kind introduction. And thanks to the HCH for inviting me to this program. I'm really honored to be a participant here. And my presentation, I will use a couple of slides, and I will share my screen for this purpose. As we have just heard, after the end of the war, the Second World War, there were trials of the perpetrators of the Holocaust in Nuremberg and other tribunals. And that history is what has been important in terms of understanding the dealings with atrocity crimes in other places. The lessons from the Holocaust and the trials of that particular time have been carried forward with international criminal justice and the creation of international criminal tribunals, particularly in the 1990s. For African countries, there have been many conflicts which featured or essentially were very brutal in the outcomes, particularly for victims. And the question has always been how to deal with these particular perpetrators for these crimes. As I go on, I will give examples of what has happened, but I want to start with the framework of international human rights, which is the basis for the creation of these crimes that we have today. So international human rights law protects human beings, but there are aspects of it which impact human individuals and the aspects which affect communities. So we have individual violations of rights and we have mass violations of rights. And what we are considering today is related to mass and serious violations of rights. And the term atrocity crimes is what is the umbrella term, at least that some have adopted today. And they cover crimes such as genocide, crimes against humanity, and war crimes. Some people include the crime of aggression, which is state conduct. But for the purpose of this particular presentation, we'll be focusing on genocide, crimes against humanity, and war crimes. I also use the terms accountability, impunity, and justice frequently because the goal is to get justice for victims of crimes and avoid impunity for this conduct. In terms of the perpetration of these crimes, I'll give examples of genocides. Genocides have occurred in Rwanda, in Ethiopia, in the Sudan, and in Burundi at various times. And crimes against humanity and war crimes are featured in conflict countries, such as the one which are listed here. Some of them are ongoing. Some have gone, some have been in the past, but many of them, some of them are still ongoing, and efforts to stop the wars have not really succeeded. So how do we get individuals to be accountable for their conduct? There are two principal forums for accountability, the National Forum and International Forum. The National Forum is the countries where these crimes occurred, and that is the preferred option, that the countries that are responsible, where these crimes occurred, should have the first opportunity to deal with the crimes. And the primary mode of accountability is usually criminal prosecutions, even though in some cases, we also have non-criminal justice approaches like the establishment of truth commissions and the payment of reparations, the use of traditional reconciliation mechanisms, and other non-criminal justice approaches like memorials and memorializations, which have been established over time. At the international level, there are a couple of options. One has been the establishment of international criminal tribunals, the ad hoc ones, and specifically in relation to Africa, the one which is relevant is the International Criminal Tribunal for Rwanda, which was established after the 1994 genocide and operated until 2016. And once it's concluded its operations, its work was folded into the residual mechanism for criminal tribunals, which combines the work or whatever remains of the work of the Yugoslav Tribunal and the Rwanda Tribunal. Another option outside of the ad hoc tribunal is the Permanent International Tribunal, which is the International Criminal Court, which began in 2002. So this is one which is ongoing and has a lot to do with cases from African countries. The other option is the creation of hybrid tribunals, which has been a combined effort between the United Nations and some countries. And the one which is particular to Africa with the UN is the Special Court for Sierra Leone, which operated between 2002 and 2013. And another one operated between 2013 and probably 2017, which was created by the African Union in collaboration with Senegal, which is the Extraordinary African Chambers in the Senegalese courts, which this was designed primarily for the case concerning the former president of Chad, Hissène Habré. The ongoing Special Criminal Court for Central African Republic, it's a recent endeavor, and its mandate has just been renewed for another 5 years. So probably it might end around 2028, but we'll wait and see for that. Outside of these national and international bodies which have been created, there is another stopgap measure or another option which has been prominent in recent years. And this is the use of the national courts of foreign countries to prosecute crimes which are committed in Africa. So many of these are in Western Europe and Northern Europe, and these are for cases from West Africa, from North Africa, and from the Great Lakes region, and also in Canada and the United States, which for the most part are for cases from West Africa and the Great Lakes region. And the options in this particular forum are prosecutions, because these countries have laws that enable them to prosecute crimes which are committed in foreign countries. And there are also universal jurisdiction laws relative to crimes which are under international law, and these prosecutions within these countries help to close the jurisdictional gap that is created when people flee from the countries where they committed the crimes. Within these other countries as well, there are quasi-criminal options, including immigration proceedings, which are used against these particular individuals where they are fugitives. Sometimes they revoke citizenship and then deport them back to their original countries. And in some cases, there is the option of extradition, which I will examine at this point. So for the different fora for accountability, I'll give some examples. So National Forum in Ethiopia, there was a revolution in 1974, which led to massive violations of rights, and a genocide was determined to have occurred within Ethiopia. So the Ethiopian government launched trials of its citizens who are accused of committing genocide. Much like Rwanda also had national trials for people who are accused of committing genocide in 1994. In addition to the national and regular courts of Rwanda, Rwanda established the Gacaca courts, which handled hundreds of thousands of cases related to genocide. For the International Tribunal, I referenced the International Criminal Tribunal for Rwanda. In its existence, it had 93 indictments and concluded proceedings for 82 accused persons. And presently, there are still 5 fugitives from justice. And these are the kind of things that we're concerned about, that people run away and escape, and there's no means to bring them to justice. They've not found them. If they find them, they will still bring them to justice. For the ICC, International Criminal Court, which is the existing permanent tribunal, majority of its cases are from Africa, which is also a source of consternation for some people. But for present purposes, we just know that the ICC is dealing with cases that come from Africa. For hybrid tribunals, the Special Court for Sierra Leone was focused on the conflict in Sierra Leone, and his most notable defendant was the former president of Liberia, Charles Taylor, who was sentenced and is serving his term of imprisonment presently in the United Kingdom. The extraordinary African chambers, which I referenced, focus solely on the trial of Isene Abre and some of his henchmen in Chad. And for third country prosecutions, these are some of the countries where these prosecutions have taken place. And these are the places where accused persons have fled over time. Regardless, with all these options that exist, there is still some gap that exists. One, because sometimes the accountability forum does not exist, or it does not apply, particularly where there are no laws to prosecute the individuals. And you cannot create laws after the fact, because it will run afoul of the prohibition of ex post facto laws. So some accused persons do what I call forum shopping. They shop for the places where there are no extradition laws and then run to those places. And it is difficult to extradite them if they have acquired citizenship of those other countries. So extradition is necessary, but most countries do not extradite their nationals. Extradition itself is the request and consent to surrender an individual for the purpose of prosecution or the serving of sentence that has been imposed. And there is a rule in international law regarding some international crimes. There is the rule of extradite or prosecute. And many countries, or some countries in some cases, refuse to extradite and refuse to prosecute. In the cases which I've mentioned, in the countries which I highlighted earlier, there have been refusals by Finland, by the UK, and by Switzerland to extradite people back to Rwanda or to places where crimes were committed. But in some of these cases where they refused to extradite, they decided to prosecute. So one of the notable cases was France, which refused to extradite people for a very long time until it decided to start prosecuting them rather than extradite. And another aspect of what I call the impunity gap is the different standards of justice that has been witnessed even in the efforts that we've noticed or that we've acknowledged. One of these issues is what I consider the disparity in sentencing, or what some people consider lenient sentencing. So one case which I will compare is that of Nyonteze, who was an accused person from Rwanda, and Akayesu, who was also an accused person from Rwanda. They were tried in different fora. Nyonteze was tried in Switzerland because Switzerland would not extradite him to Rwanda, and Akayesu was tried before the Rwanda tribunal. The case against Nyonteze was disposed of in 1 month. The case against Akayesu was 15 months. The charges against them were similar, even though they were in different courts, but the charges were similar. One took longer to prosecute, and in terms of sentencing, Nyonteze was sentenced to 14 years imprisonment. On similar facts, Akayesu was sentenced to life imprisonment. And some people have observed that what accused persons have done is usually to go to places where the sentencing is lenient so that they will take their chances there. Even if they are convicted, at least they will serve the sentence and then resume their lives. as opposed to being prosecuted within Rwanda, for instance, and they will be sentenced to life imprisonment. So this is one of the problems which we see. Another issue is what has been characterized as the externalization of justice. The problem with criminal justice is that these crimes were committed in specific locations. Then it is incumbent upon the justice system to have these crimes prosecuted in the places where they occurred. As we see, many cases have been prosecuted outside of the places where the crimes occurred, and the lessons that prosecution should hold for people within those countries is lost, because by the time those crimes are prosecuted, it's either people are not paying attention to it, information does not filter back to the communities where those things are done, and the lessons it should hold for people within those countries, probably the deterrent effect is also lost. And the fact that other people are sitting in justice over the crimes committed in other countries is a source of consternation for some people. And therefore, it also holds some implications for international criminal justice. Should cases of genocides, crimes against humanity be prosecuted outside the countries where those crimes occurred, it is convenient for the international justice or international system to hold these people as examples for the world. But in doing so, sometimes the lessons is lost for the communities where this is occurred. Another issue is the length of proceedings, particularly with the ICTR. The ICTR was notoriously slow at the start, and it was a matter of concern for advocates that they had to do something about it. And I cited the example of Akayesu, whose trial took 15 months, and some cases took longer. But I'm not sure that it's something we should be fixated upon, because we want to be sure that justice is done, and justice is done properly. We should not hurry to produce some form of justice just to satisfy our desire that, oh, we did it in good time. It is necessary that we do it properly and we do it well. One other issue is the cost of trials. And this is one of the things which relate to impunity. For the ICTR, I'll give us some numbers. For the 17 years of its existence, this is the Rwanda Tribunal, the cost of its operations was between $1.5 billion to $2 billion. And it had 75 trials. So the cost for each of these trials would be around $20 million. And we can compare that with the Gacaca system in Rwanda, which spent about $40 million for its 10 years of operation, and it prosecuted about 1.9 million cases. So some people think that the Gacaca system was more efficient at least in the use of the funds that were available. And some people also think that the ICTR did what it could in circumstances, but it was a lot of money. For Sierra Leone, the special court for Sierra Leone it was a poorer tribunal because it didn't have as much resources as the Yugoslav tribunal or the Rwanda tribunal. An estimated $260 million was spent over 11 years, and it had trials for 9 individuals plus Charles Taylor, and the estimate then was around $20 million for each of these trials. But if we disaggregate that, there were 3 main trials, so 3 individuals in 3 trials, it came to about $70 million for each trial. And Charles Taylor, the president of Liberia, the former president of Liberia, his trial was estimated to cost $50 million. And when we think about this, is it really worth the price to spend so much money on prosecutions? Again, going back to the cost of the Special Court for Sierra Leone, at this material time, the budget for the entire judiciary in Sierra Leone was less than $3 million annual budget. And so much money was being spent on these individuals for their prosecution. Is it really worth it? And if we read the statutes or the enabling laws of these tribunals, the focus is on the people who bear the most responsibility. If we were to try every person who is accused of committing a crime in a genocide or in situations of crimes against humanity or war crimes, how many of those can we really afford to prosecute? And in this case, as with other endeavor, international funding is really critical to getting the prosecutions off the ground. So the number of potential defendants will affect the number of people that can be prosecuted. And in the case of Rwanda, at some point, I mean, if we were to have an international system that will prosecute 1.9 million people that the Gacaca courts did, it simply will not have occurred. And so some things have to be prioritized, but in prioritizing some accused persons over others, there is some impunity or gap that is being created in that. Because if you don't prosecute everybody, some people essentially are walking away free. So in looking at the future, what can we draw from these particular experiences? In some sense, it looks very depressing and not very promising. But at the same time, if we think about what has been done in the last many years, particularly since the 90s and the 2000s, we can say that that window of opportunity that individuals have to escape justice, that window is closing gradually. For every case of impunity that we see, there is an example of justice being done or the process of being done. And what we need to do is to avoid what I call, or what has been called, the willful burying of the past that is legalized by the rule of law. And if we think about the cases of Charles Taylor, for instance, it seemed impossible at some point that Charles Taylor would be brought to justice for what he did. So also, there are some individuals, for instance, the former president of Sudan, Omar al-Bashir, there is just the possibility that he might be surrendered someday to the International Criminal Court for prosecution for what happened in Darfur. So as much as some people have been escaping justice, it is possible that other people will not escape justice. And as we think about the future, or the present and the future, we continue to consider the role of the law as an instrument of accountability. The law has a very prominent role because that is the basis for the prosecution of all these people. It establishes the standard by which we hold people accountable, and it is the reference point when we try to prosecute people for their crimes. So one or two instruments I will refer us to include the Constitutive Act of the African Union, which in Article 4, Paragraph H, enshrines the right of the Union to intervene where there are cases of war crimes, genocide, and crimes against humanity. So this is one of the few instances where the right of humanitarian intervention is enshrined in international law, and it is something that we can hold the African Union and African countries to, that where there are atrocity crimes being committed, the Union has a duty and an obligation to intervene. There is also the Malabo Protocol, which establishes or which provides for a criminal jurisdiction for the African Court of Justice and Human Rights. And this particular protocol helps extend the sort of crimes that are peculiar to African countries or are peculiarly committed within African countries, including things like mercenarism and trafficking of drugs. All of those are things which go beyond the traditional war crimes, genocide, and crimes against humanity. So this is the presence of these laws, the adoption of these laws helps to create a situation where the possibilities are less and less for those who want to get away with crimes. And as much as the law is an instrument of accountability, I also want to stress that there are limits to that, because human rights violations, which these crimes amount to, they are due to problems within society. Many of them emerge from causes that are deeply embedded in the structure of our societies. And what the law does is just to address the visible layer of that problem. The law does not look at those deep issues that societies are grappling with. The law is not a substitute for socio-economic policies that are needed to combat these structural problems. And we should not place a weight or a burden on the law which the law cannot bear. Efforts also must continue to combat impunity. There are ongoing conflicts in Ethiopia, in South Sudan, and many African countries are witnessing a resurgence in Al-Qaeda's activities, ISIS, ISIL, in different parts of West Africa, and they are spreading to East Africa and some parts of Southern Africa. All of those things are going on as we see. We owe it to victims and societies to ensure that justice is provided for victims and that they live lives which are free of unnecessary violence. And this is one of the reasons why we have to close the impunity gap. The gap should not exist. And if they exist, they should be closed. Let me stop sharing. And share again. So I just want to, as I round up, I just want to address a specific aspect of this issue, which some people are really concerned about. Why do we have trials? And I offer these particular thoughts based on the work of David Liban. Trials are very useful in projection of norms, and according to Liban, trials are expressive acts that broadcast the news that mass atrocities are in fact heinous crimes and not merely politics by other means. Only trials can communicate the inherent criminality of political violence against the innocent. And when we decide not to stage criminal trials, it is no less an expressive act than the creation of tribunals, and the expressive contents associated with impunity and summary punishment are unacceptable. And both these positions are assertions that political crime lie outside the law. the point of trials backed by punishment is to assert the realm of law against the claim of politics. There are always claims that we should not hold trials and that the money can be better spent to develop these societies. But it is something for us to consider that, for one, the people who commit the crimes feel that they have some liberty or license to be able to do it, and that they can do it with impunity, that they will get away with the crimes that they will commit because they are usually backed by the authority of the state. And because they are backed by the authority of the state and by influential elites, it is just for them very easy to commit crimes and not be punished. And they find examples of people who have committed crimes and never got punished for their crimes. So it is necessary that we close all these loopholes that exist that allow people to commit crimes and then run away to other countries. And the issue of extradition that I mentioned earlier is very important. Extradition laws are very delicate because you need extradition treaties between countries. There are no broad extradition treaties between countries except probably for Europe and some other countries. And in these cases where you have an extradition treaty, the places where the crimes are committed do not have extradition treaties with European countries. And because the accused persons or the suspects have run to those places, they acquire the citizenship of those countries, which then make it impossible to extradite them. And they go to extradition-proof jurisdictions for those cases. And if we have that ongoing, the places where crimes are being committed at present, the message that comes across to them is that they will not get punished. So the conflict in the Democratic Republic of Congo has been ongoing for almost 30 years. It's not ending, and there must be something that is feeding that and allowing that problem or the conflict to continue. That's one thing to think about. And also I want to mention the role of non-criminal justice options that has been pursued by the United States, for instance, and by Canada. In some cases, they find that they cannot prosecute these people who have come to the United States, and what they will simply do is to use immigration laws against them. And that's what has been helpful for some of the accused persons from Rwanda, for instance, where the US has no laws to prosecute them, and then the US decides through immigration proceedings to deport them back to the countries where they came from, particularly because they lied to immigration officials in obtaining the visa to the United States. So this is one of the options which has been pursued by the US and has been very effective, at least in bringing some measure of justice for victims, because then once they're extradited back to Rwanda or to their countries of origin, then justice can proceed against them. And so I'll just go back and go over what I've just been presenting the last couple of minutes. One, we have different fora for criminal justice. There's the national process, the international process, including ad hoc international tribunals. We've had hybrid tribunals for prosecutions, and we've had third country options for prosecutions. And between all of these, we should take care of most of those suspects, but some people go to places where they are even under the radar. So that's one part of it. And so does the future hold is the future very bright as we might want to see it? Probably we think it's a half full or half empty situation. And I'm hopeful that after some time, these doors that are open to perpetrators of atrocity crimes, that door will become closed. Let me stop here and then take questions.
Thank you so much, Babafemi. There are a number of questions, and I want to pick a couple to ask you. And the first one comes from Mike, and he asks, can you expand on the issue of international courts taking so long to conclude a case? What can be done to speed up justice without sacrificing rights? And I want to add to that a second part, which is there an optimum time frame for these cases to be tried?
Thank you. The prosecutions generally take a very long time, particularly because these are not the ordinary theft, muggings, and regular crimes that are committed. They are committed in the context of a policy adopted by the state or adopted by some non-state agencies. And in that context, one has to dig deep to find layers of responsibility in those kind of. Then also, you also have difficulty in obtaining evidence. And if you have difficulty in obtaining evidence, sometimes you have the absence or the lack of witness protection. So assembling the case against individuals takes a very long time. And if it takes a long time, then presenting them before a tribunal also takes a long time, because the individuals want to maximize the rights which are afforded them. And so if we take the case of Milosevic, for instance, in the Yugoslav tribunal, it took a very long time. You have literally hundreds of witnesses, and sometimes the examination of a single individual or a witness can take days. So it takes a long time for those things to occur, or for the prosecutions to occur. So, and I'm not sure that there is a particular time frame that is that is required to achieve justice. But for the international system, the way the rules are written, they try to blend different forms of law, like civil law and common law. And so it is in that attempt to bridge the divisions between those two systems of law that you give as much latitude to the defendants as possible to ensure that they cannot cry foul at the end of the case and say, oh, they are victims of injustice, because you cannot substitute one form of justice, one form of injustice with another form of injustice. So to speed them up, I think that they may have to adopt maybe rules like U.S. criminal procedure cases, cases in U.S. courts, but I'm not sure that that can happen. It is always difficult. So for cases that go on in the Netherlands, for instance, in The Hague for the International Criminal Court, you have to ferry witnesses from, let's say, Rwanda to The Hague. You have to arrange for their visas, you have to arrange for their transportation, you have to arrange for their stay, lodging in all those places, and the times they will spend. So all of those things take time. And because they take time, and because the investigations also take time, and particularly because the cases are usually heard away from the location of the crime, unless, as some countries have done, they move away from their own courts, then they go to Rwanda, for instance, and then investigate, and then conduct their own investigations, and then go back. That's one of the reasons why it's very difficult to have a shortened lifespan of time for these cases. And I'm not sure that it can really be addressed the way we want it to be addressed. We just have to understand that justice must be done. And if it takes time, we just have to live with it. The alternative is to let the people walk free. There was a particular case in the Rwanda tribunal. The guy was arrested in Cameroon. And there was a delay in transferring him to the Yugoslav tribunal. And with that delay, by the time the case was commenced, the accused person said there was undue delay in his trial. And then the tribunal agreed with him and ordered his release. And it was very, very infuriating that somebody is accused of genocide, and the only reason they released him was because he was not tried on time. So Rwanda then complained, and that it will stop all cooperation with the tribunal if it released that individual. And then there was an appeal in the tribunal, and then they said, look, if the man is eventually convicted, the time which he has been held unduly long, that undue length can be subtracted from his sentence. And that's exactly what they did, because the option was to release him because, he has not been tried on time. And this is one of the things we talk about in terms of the disparities in justice and different standards of justice being applied to individuals. So that's a long answer to a very short question. I'm sorry.
No, that's a great answer. And that example, you're right, is so infuriating that he should be released. So Babafemi, another question comes here from Julia, and she asks, what dynamics exist regarding race and racism present in Western countries or institutions involved in prosecuting these crimes?
Sorry, can you take it again?
Yeah. What dynamics exist regarding race and racism when Western countries or institutions are involved in prosecuting the crimes?
Yeah, okay. So it's one of those very touchy subjects of this particular enterprise. So for instance, when Belgium adopted universal jurisdiction laws that allowed the prosecution of people for crimes committed outside, Belgium. So, and until the US leaned heavily on Belgium, the law was in the statute books until the US said if they did not amend it, then they will pull NATO headquarters out of Belgium. And then Belgium decided to amend the law to make it very difficult to prosecute those cases in Belgium. Then there was also the aspect of Belgium having in its own national law immunity for the monarch. So Belgium has immunity for the monarch, and then says other monarchs, other countries don't have immunity. That was one problem. And there were other issues also with Belgium, with France, and some other countries seeking to prosecute people for crimes committed in Africa. With their colonial power status in Africa, they committed crimes as well. So what gives them the moral ground? What moral ground do they have that they stand on that allows them to then begin to prosecute people for crimes which they also committed, for which they have not atoned? So that's one part of it. There was the back to the Belgium case. There was an indictment of the Congolese foreign minister, and that he was involved in some crime against humanity and things like that. And so the case went to the International Court of Justice, which essentially asked Belgium to withdraw the indictment. But Belgium, France, to a lesser extent, Spain, all of these countries, like I said, people wonder why it is that they take it upon themselves to prosecute cases that come from Africa. That it's another version of the colonial enterprise, that they try to say that they are still the masters of these individuals. They're the ones who determine what the conduct is. They're the ones who determine what essentially is punishable and is not punishable. And that is then expressed in what we call international criminal justice, and which we then see in international criminal court that only indicts Africans, and no other groups of people have been brought to trial before the International Criminal Court. So that dynamic of race and racism is still present in all of this conversation. Mm-hmm. But there are victims of these crimes. Some people lost their family members, entire communities were wiped out and all that. The conversation about race and all that should not displace justice for those victims. That's just one way to look at it.
Mm-hmm. Mm-hmm. Very interesting. Babafemi, another question comes here from Marilyn, and she asks, Professor, can you address differences in post-conviction outcomes, conditions of confinement, possibility of early release, etc.?
Okay, thank you. This is another version or another part of this conversation. Some of these accused persons, they prefer to be incarcerated in Europe because they know that the conditions of incarceration in Europe are much better than the conditions of incarceration within African countries. So they take their chances and decide, I'll just go to Europe. If they arrest me, they arrest me. Being in prison is not a big problem. 10 years, I'll be out. And the case of Charles Taylor, for instance, Charles Taylor was convicted. It was then Britain or the United Kingdom offered prison facilities for Charles Taylor. And some estimates say it cost them about £100,000 every year to do that. Maybe every month or every year to do that. And the conditions of confinement is such that some people feel that that condition of confinement is also an aspect of injustice if it's very harsh, and which is one of the reasons why countries refused to send or extradite people to Rwanda until Rwanda reformed its prison laws and all that and built new prisons. And so Rwanda now has some prisons where convicts from other tribunals then are sent to Rwanda for incarceration. Some places also have facilities. Some of the tribunals also have had early release for individuals. They've done that in the special court for Sierra Leone for good behavior. Some people are released early into the community. So it's a mixed bag, and it's not a perfect situation, but I think that there are still concerns about sending people to prison, prosecuting somebody for $50 million, and then sending them home after 5 years. And it's also a problem that some people think that the cost of these prosecutions, this enormous cost, that the tribunals have to justify them. And so they have to find ways of convicting people. I mean, how can you spend $250 million on the prosecution of somebody and the person walks free? Why spend that kind of money on the individual? So, all right.
Mm-hmm, mm-hmm. So we have time for, I think, one last question here. And I want to present a question from Marcy, and she writes, thank you for this informative discussion. Can you please explain further on why the extradition of alleged genocide or mass atrocity perpetrators does not consistently occur? And why are there loopholes even when there are extradition treaties?
Well, there are multiple reasons, I mean, that one can consider that accounts for this. One, the countries where the individuals flee to have no interest in, or little interest in, sending those individuals back. The people that go to those countries sneak in, sometimes under false identity, and then acquire citizenship of those other countries, which then make it very difficult to extradite them. Because now they are in places where they cannot send them back to Rwanda or any other country. Sometimes it is a case of geopolitical considerations. There is the case of Khaled Nizar, the former defense minister of Algeria, who was in Europe, and they had to find ways of sending him back to Algeria very quickly because some countries, some people wanted to prosecute him. And some other places too, where there is an interest in extradition, but either the country does not want them back, they just want them outside their country. And so they don't want these particular accused persons. So regardless of whether there is even the possibility itself, they just don't want them. They just don't want to see them. So many of these things they meet somewhere. All these factors meet somewhere. And for the most part, it goes back to the considerations of that some people think is a racial issue, that they feel that their laws are superior to the laws of Rwanda or to the laws of the DRC and other places, and that those individuals should not be subject to those kind of punishment in those countries. So regardless of the gravity of the crimes that those people are accused of, they still don't feel that they should be sent back to those places. And that's one of the tensions between the ICTR, the Rwanda Tribunal, and the Rwanda government. Rwanda reformed its laws over and over and over again to meet the requirements of European countries, essentially modeling the law of European countries. Still, they refused to send them until it became embarrassing that they would not send these people back to Rwanda. What was the interest in holding these people that you are not going to prosecute? I mean, in the case of the United Kingdom has a situation where there was a request for extradition, and the judge that looked at the case said these individuals had a case to answer, and it was in their best interest for a court of law to examine the case against them. And then the judge refused to extradite to Rwanda. I mean, one could not understand that. Those are things which still continues to perplex individuals who are looking at this issue. So,
This is so informative. Thank you so much, Babafemi. Are there any last words that you'd like to leave us with for this program today?
Last words. I just enjoin us to keep helping these countries who are seeking justice for crimes committed in their own countries, and so for them to understand that we are in this together, and that it's a common humanity that is assaulted when people are victims of genocides and crimes against humanity and war crimes, and that these are things which all of us working together can put an end to. Can't say more than that.
Those are such important words, that this, as you said, it's our common humanity that is assaulted when these things happen, that we have a responsibility to bring these people to justice. Thank you so much for sharing all of your knowledge and research with us today. I think we all have learned so much. I really appreciate it. Thank you for being a part of this program.
Thank you.
Thank you to everyone for joining today's program. One of the biggest compliments you can give to us is to share this program with a friend, colleague, or family member. You can send them a link to this program or invite them to join live on a future Tuesday program. February is Black History Month, and we are reminded to take stock of where systemic racism persists and to give visibility to the people and organizations creating change. It can feel overwhelming to consider how one can combat the inequality that surrounds us. And at our next Lunch and Learn program on February 7th, Dr. Raylina Joseph from the University of Washington will discuss some of the steps each one of us can take. And this next program will be offered in partnership with the Northwest African American Museum. Our Lunch and Learn programs are possible because we have such a great team at the Holocaust Center. Thank you to Richard Green, our Museum and Technology Director, who is working behind the scenes to make this program run smoothly. A huge thank you to our CEO, Dee Simon, and to our entire team who make all of these programs and resources and good work possible. Lori Werschel-Cohen, Paul Regelbrug, Jessica Michaels, Julia Thompson, Morgan Romero, Amanda Davis, Devonshire Lockie, Katie Lawrence, Branda Anderson, Anna Morris, and Demetria Spinrad. Thank you again for joining us today, and we hope to see you at our next Lunch and Learn program on February 7th. This concludes our program for today.